Good evening to everyone. So we would like to have a brief session tonight as part of the revisions that we are making towards the writing of the law school entrance examination. As I always tell you, the philosophy of my engagement with you is that you have done the substantive learning already. So what I am doing is to help you to mop up or to help you to clarify maybe matters which you are not clear about, and also to give you some useful hints or guidance regarding how to resolve your questions. We keep jumping from one of the 6 areas to another. Last time we met on Sunday, we did some discussions around constitutional law. And tonight, I am taking you back to law of contracts. So I intend to do a preview question. And after the preview question, of course, the focus or the aspect of law of contracts we are revising tonight is about remedies. And we're focusing mainly on the remedies for breach of contract. So we have some substantive discussions around that. And before we do the substantive discussion, there's a question I would like to actually start with. I mean, pick from one of the various questions which are out there. So there's one problem-based question, and then there's also a number of multiple choice question. So we work through that, and having worked through that, I will then revise with you the basic principles in this area of the law. I will then take your questions and we'll end the session for the night. It's going to be very brief and we hope it will be effective and just brief. Okay, so let's take one of these questions which are in the pool of questions out there. In Pink Sheet Poultry Farm Limited against Ezecool Refrigeration Limited, the plaintiff asked the defendants to repair their broken down air conditioning system, which they use to keep their hatchery at the right temperature for their broilers. The defendants were informed that the plaintiffs have no backup system and that they should finish the repairs within a week. The defendants delayed for 1 month in repairing the system, during which time the plaintiff lost 10,000 checks, which they could have sold for 50,000 Ghana cedis. The plaintiffs also had a contract to supply 1,000 broilers to an overseas client worth 20,000 US dollars. The plaintiffs are suing the defendants for breach of contract to recover the sums of 50,000 cedis and 20,000 dollars respectively. Advise the plaintiff as to the basic rule for recovery of damages, which they call to use in determining whether or not the sums are recoverable. So this is a typical question from law of contract, particularly around remedies, damages for breach of contract. So very straightforward. I'm just using this just for purposes of illustration. Just for purposes of illustration, so that once we use this for illustration and we review the principles, should any question come in the area of, let's say, damages for breach of contract, you should be able to deal with that competently and do well. So as we know all the time, if you have a problem-based question in contract, don't forget the basics. If I say don't forget the basics, some of us, the problem we have is that when we, especially those of you who have done these exams more than once or something like that, when we get the question, we begin to think that because it's law school entrance examination, probably something different from what we learned in the law faculties regarding how to resolve problem-based question is expected of us. I think that is a mistake. So don't let us make that mistake. A problem-based question is a problem-based question. And the approach is always the same. So as we know, if you have a problem-based question, we often talk about like the IRAC, or some people call the IPAC, whatever. So IRAC, we are told area of law, issue. Then we do what do you call like the statement of relevant law or rules or and then you do the application and analysis. And you do your conclusion. Yeah, so basically this is what we use to resolve problem-based question. But as I keep saying to some of you who have heard me before, the answer should be well structured. So typically, you must have your introduction. So the introduction tell us about the relevant area of law. And as I have indicated before, because of the unique nature of this entrance examination, if I say unique nature in the sense that the paper is just headed entrance examination, they will not specify that these questions are questions from law of contract, or these questions are from law of tort, or these questions are from law of immovable property, or from Ghana legal system, or constitutional law, or criminal law. The question will just be there. And that is why it is useful to state the area of law. And when you are stating the area of law, it will be helpful, in my view, if you even added the bigger subject area. So that like the assuming, I mean, I'm not saying that this is anything, but assuming for purposes of discussion that you had this scenario as a question in your exams, we'll be interested in hearing you telling us that the scenario depicted in the question raises issues which are relevant to law of contract. And these issues are, one, that you start telling us something like that. I'm not saying you use the same wording, but just to give you a sense of what we expect you to do properly. So let's go through attempting to raise the issue. And the way to do it is to take your time. You read, of course, you read the passage or the scenario from the beginning to the end quickly once. And once you do that, immediately, the bigger area of law will register in your mind. This one, for example, as soon as you read it, the bigger area of law is law of contract. And then, law of contract, which particular areas are implicated, are relevant. And straight away, you will notice that it's about remedies for breach of contract, or specifically damages for breach of what? Contract. That is the relevant area of contract here. Now you want to get the specific issues. So in getting a specific issues, some people have written some things. What have they written? Because is there a bill which keep? All right. Okay. There's no bill which is ringing from my end, but that someone has explained. The Zoom, unless you want me to lock, you want me to lock those who are not here. I can lock the class so that nobody can come in again, so that the noise will stop. But that may also not be fair to others, isn't it? At least my account, I'm using Zoom account. It can take up to 300 for the time being. Yeah, okay, so okay, so now we want to raise the issues. How do we raise the issues? In order not for any issue to get lost on us, let's read each sentence. So we start from the beginning. Maybe while we are doing it, there'll be nothing wrong if you can try your hands by telling us what you think some of the issues are in the chat. So you can, so let's do it this way. If we are going to read together, you can try your hands by using the chat to state the issues which you have raised, right? So in the plaintiff asks the defendants to repair their broken down air conditioning system, which they use to keep their hatchery at the right temperature for their broilers. Does this sentence provoke any viable issue having regard to the area of law? And as one of you have indicated, I think, God love, that the area of law is remedies in the specific was damages for, and specifically damages, okay, for breach of contract. Okay, yeah, so as I said right away, this is by law of contracts. The reason why I said that it's useful to state, let's say, law of contract is that the paper that you are doing, this problem is just given to you, and nobody will tell you that this question is under tort, this question under landlord, this question under this. So you have to work it out. And that is why you will know yourself. And then you probably also enable your examiners to understand your approach or viewpoint. If you could classify the problem under, let's say, that the particular subject areas, if it's maybe contracts, tort, okay, if contract is relevant, under contract, which areas of contract are relevant? And we have stated that remedies for breach of contract, especially damages. That is it. I don't see any other area of law being directly relevant here, but assuming you had, let's say, tort also being relevant, then you also have to tell us which area of, let's say, tort are relevant. But as I said, for now, I don't see that here, so don't let us waste our time there. So you want to continue with our reading, trying to raise the defendants were informed that the plaintiffs have no backup system and that they should finish the repairs within a week. Does that raise any issue? I'll be monitoring from the chat, so we'll be putting your issues there. Then you go to the next sentence. The defendants delayed for 1 month in repairing the system, during which time the plaintiff lost 10,000 checks, which they could have sold for 50,000 cedis. Does that raise any issue? Let me see in the chat. The plaintiff also had a contract to supply 1,000 brawlers to an overseas client worth 20,000 US dollars. Does that raise an issue? State it in the chat. The plaintiff are suing the defendants for breach of contract to recover the sum of 50,000 and 20,000 US dollars respectively. Any issue? And then the question taskmaster is directing us what we should do. That advise the plaintiff as to the basic rule for recovery of damages, which the court will use in determining whether or not the sums are recoverable. Well, this type of question, for example, the examiner has done what they call the pinpointing for you and has more or less pinned you to particular aspects. So the question has given you the focus already. And the focus is that you are to tell us the rules for recovery of damages that will guide the court in making determination as to whether the plaintiff can actually recover the sum of 50,000 cedis for the 10,000 checks that plaintiff lost, as well as the $20,000 for the 1,000 brawlers, which plaintiff was supposed to have delivered to an overseas client. Let me look at the chart and comment on some of the issues that you might have put out there. Okay, so let me see. Let me go up. Okay, so whether or not there's a valid contract between the defendant and the plaintiff. Well, that issue, my comment is that it's not necessary. It's not necessary because if you read the question globally as a whole, clearly, there's no doubt that there was a contract between the plaintiff and the defendant, as it were. We don't need to raise an issue on a matter which appears to be settled, right? And so that is not necessary. Another person, whether or not there's a contract between no, that is not necessary at all. So don't waste your time on that. Let's move on. Yeah, so somebody has even reacted. Whether or not plaintiff will succeed in an action to claim damages for contracts. That is fine, but my difficulty with such formulation, right? Such a way of framing the issue is that it is too broad and somewhat vague. It is better to I always tell my students of law of contract that let your issues always bear the color of the facts, right? The relevant aspect of the facts. Let them give completion to the issue. So let's look at what the other person has done. Whether or not the defendant failure to repair their condition within the agreed time period constitute a breach of contract. I think in a question like this, right, you have to state right away that there is no dispute as to breach of contract having occurred. There's no dispute about that. Now, the dispute will center on the type of losses emanating from the breach of contract for which the innocent party, the plaintiff, would like to recover from the defaulting party, the defendant, as it were. I think that is where the controversy is. So one will say that, well, this loss shouldn't be made compensative because it is not related to the breach of the contract and so on. I think that is, those are the issues. And that is why the question is even telling us that here, straightforward, we have a number of checks which were destroyed and they are worth 50,000 cedis. Now, there's no doubt that the destruction of these checks were as a result of like the breach. I mean, like they, if you like, they are linked to the breach, and let's put it that way. So can compensate in terms of their value, can it be recovered from the defaulting party? And then the other number of checks which were supposed to have been exported, which plaintiff will not be able to do as a result of the inability to get the hatchery running and all that. Can the plaintiff recover that expected revenue from that export, which it could have made? That is 1,000. You know, so those are some of the things. Yeah, okay, so another person at all, whether or not the plaintiff is entitled to their claim. Okay, fine. So which claim? Whether or not plaintiff is entitled to recover, I mean, you can break it down. Whether or not plaintiff is entitled to recover 50,000 CD for the loss of the 10,000, is it how many, 10,000 checks? Okay, then the other one, break it down again, whether or not the plaintiff is entitled to recover 20,000 US dollars for the inability to deliver the 1,000 dollars to the overseas client or whatever. So there are various ways in which we can, but the most important thing is that don't let the issue be too general. Let it reflect the color of the fact. Okay, so let's see. Godlove has also come again. Whether or not plaintiff can recover sums lost by way of damages. Okay, that is fine, but you still need to focus it. Sums, what sums? Why not use the information from the question? The question has specified 50,000 CDs for the 10,000 checks and then the $20,000. Yeah, so use those information so that it's more specific rather than general. Then let's take the other one. Okay, one early said that whether or not plaintiff could recover for both general and special damages. Okay, that is fine, but you have to tell us, so which one are you considering as the general damages and which one are you considering as the special damages? Maybe you could say that whether or not plaintiff could recover 50,000 CDs for the loss of 10 by way of general damages. And then you do whether or not the plaintiff could recover $20,000 by way of special damages for the inability to deliver on the 1,000 brawlers or something like that. Good. Yeah, so I think so far, so good. Those who have shared their, you know, what they were able to do with us in the chat. I think it's not bad. Yeah. So we would like to just 1 minute. I'll call you. Ellen, I'm online. I'll call you back. Good. Yeah. Okay, so that is fine. So let's okay, another person, if you whether or not the plaintiff can recover sums of 50,000. Okay, that is fine. Okay, now let's come back. So essentially, if you look at this, we have, if you like, two main issues. This is a type of question in which we didn't have to struggle with the issue because the question more or less has delineated the issues for us. And two things, one relates to recovery of the 50,000 the lost 10,000 checks, and the other relates to $20,000 for the inability to supply the 1,000 brawlers. Good. So you have this. Now, these two issues are related. So there are two ways of going about resolution of this in terms of hierarchy. I've seen one. Can Black hand is up? I'll take your comment. Just allow me some 2-3 minutes to finish making my point. Okay, so one way is to take each of these issues one after the other, right? So you take like the issue relating to whether the plaintiff can recover 50,000 cedis by way of the general damages for the lost 10,000 checks, for example. So let's say that is your issue. You take that as a heading, right? You take that as a heading, let it stand out boldly. You can even underline it. Then you go straight to state the relevant law or the rules or the principles. So since you are talking about uh, uh, damages, and for the first, we are talking about general damages, you have to tell us that damages refers to monetary compensation for breach of contract, and the purpose of awarding damages is not to be punitive, but to place the innocent party in a position, as far as money can do, that he or she will have been had the contract not been breached. You mentioned cases like Robinson and Hammond, and then a lot of Ghanaian cases, the Delmas case, and so on. Then you go on to tell us that the courts will need to determine the issue of remoteness of damages, as well as a measure of damages. And to do this, with respect to the remoteness, the court will need to find out whether the particular loss or the particular damage for which you want damages, that is a compensation, is not too remote from the breach. How does the court determine whether the damages you want to recover for the particular damage? You see, I'm using one word in two senses. Damage with the S, that is damages, is called the monetary compensation. And then damage without the S is the loss, which the innocent party is complaining he or she has suffered as a result of the breach of contract. That is why I say that you need to find out whether you can recover damages for a particular damage, that is for particular loss, which you are complaining about as a result of the breach of contract. And to do that, the court will need to find out whether the particular loss, the particular damage for which you need the damages is not too remote from the breach. And how is that resolved? We know the old case of Hadley and Bassendel, and every student of law of contracts in the common law jurisdiction knows that case. Hadley and Bassendel, and the famous principal Baron Addison enunciated that when a breach of contract has occurred, losses which arise naturally from the breach of the contract are recoverable or considered as being reasonably foreseeable, with the completion of the parties are recoverable, and so on. So you tell us these principles, and you will be stating like the case law and how these have further been developed. The clarification of that policy by Law Justice Asquith in the case of the Victoria Landry against Newman, and so on. So you tell us all this. And when you have finished stating principles and then the case law, then you make the point that once remoteness is determined, the court will have also determined measure of damages, that assessment of the damages into money. But in this particular case, the measure of damages is not really relevant because figures have already been put to the lawsuit. So we know how much money is supposed to be awarded by way of damages. So what is important here is really the issue of the remoteness. So with respect to the 50,000 CDs for lost 10,000 checks, can we say that it was such a loss arise naturally from the breach of the contract? From the time that the parties made the contract, uh, can we say that if there's a breach, we can reasonably assume that uh, the innocent party is going to lose such a number of checks, and for that matter, the market value or the economic value of it should be paid by the defaulting party as a compensation to this innocent party. So could the delay, which is like the breach here, the delay for 1 month in repairing the system, can we say that it be blamed for the 10,000 that were lost? If the answer is yes, then there's no dispute regarding recoverability of the 50,000 Ghana cedis. So when you are done, you repeat the same process for the 20,000 US dollars. But this is just a teaser as we are going to discuss the principles in a little more detail. So maybe I will skip the multiple choice question I wanted to do and quickly revise principles with some of you who might have become a bit rusty, and then we will come back to these questions. I've seen people talking about specific performance. Well, I think the question was quite straightforward, right? The question was just asking us, advise the plaintiffs with the basic rule for recovery of damages. The court, if the question had been, what remedies, right, would the innocent party get? That is where you probably be free to go to town and also explore if specific performance, for example, could be an available remedy. But having regard to the particular question that we just look at briefly, I don't think it will be worthwhile for you to waste your time. And that is another thing that we should pay attention to. I know that a good number of you might have struggled to pass these exams, and this is your second or your third or fourth time. For some of you, it's not really the case that you are not learning or you don't have knowledge of what is being tested. Some of you might have actually learned seriously. Some of you might have accumulated significant amount of knowledge necessary for you to pass the exams. Nevertheless, you may be doing something wrong. And what you are doing wrong is that you lose focus regarding what is really needed to resolve the question, right? So when a question is asked, it doesn't mean that you should tell us everything you know concerning the broad subject area. No, this is an examination and only a particular aspect is tested. So focus on what is being tested. I think that is very important. So let's pay attention to that. Before I move on to quickly, okay, so somebody has a question. Whether mitigation of damages is part of the rules. Yes? If we're talking about, we have mitigation of damages, which says that when a breach of contract has occurred, then you are supposed to take measures which are reasonable to minimize the losses which you may suffer as a result of the breach of the contract. And if there are reasonable measures you could have taken and you don't take that, when the court is determining damages, you may suffer some diminution in terms of the quantum of that which you ought to have actually be given because of maybe like your failure to do mitigation of damages. But as we know, mitigation is only needed where you don't need to do anything which is so severe, which is unreasonable, or which is extremely expensive. Okay, so that is just by the way. I think one Balak or somebody wanted to ask a question. Can you put up your hand so that I will release you before I continue? And somebody's hand was up, but the person has put the hands down. Let me see. All right. Balak said it was a mistake. Okay, that is fine. Good. Okay, so just 15 minutes, a quick revision of the law regarding damages for breach of contract. Well, as we have stated before, damages simply refers to the monetary compensation awarded for breach of contract. We have to remember the purpose for award of damages. The purpose for award of damages is compensatory, not punitive. When we say is compensatory, not punitive, it simply means that when a contract is made between A and B, if A perform his side, B will definitely get what he entered into the contract. In the same vein, if B perform his side, A will get what he enters into the contract for. What that means is that if A has performed and B does not perform, A will not get what he contracted for. For that reason, at common law, the approach is that let us direct A to pay money which is enough. Let us direct B to pay money which is enough to put A in the very position that he would have been if B had actually carried out his side of the bargain, his side of the contract. So if B is being made to pay money, which is just enough for A to get what he would have gotten or obtained, if B has performed, we are not punishing B. B is simply doing what he ought to have done, except that on this occasion, he's being made to do that by payment of money. That is what we should keep in mind. And you know the old case of Robinson and Hammond, that the aim of awarding damages is not to punish, but to place the innocent party in the same position that you have been, and the contract being properly performed. And for that reason, sometimes the court will award what they call nominal damages. And nominal damages, let us understand it well. Nominal damages simply means that the court is awarding damages for the simple reason that there has been a breach of contract, but no specific loss can be demonstrated. The common law has a certain logic, and that logic is that whenever a breach of contract has occurred, compensation should be provided. But the compensation or the damages is supposed to reflect the amount of loss which has been suffered. However, it may well happen that there has actually been a breach of contract, but there's no demonstrable loss, no demonstrable injury. You cannot actually say that you have lost this. That notwithstanding, there is a breach of contract. So to give symbolic meaning to the principle that where there's a breach of contract, damages are awarded, the court will give you some token damages, a part-3 sum. And that is why you call that a nominal damages. So just for symbolic purpose. So it's not much because there's no actual discernible or calculable loss which you have suffered. So that is what you should keep in mind. And there are two things which are relevant towards discussion of damages for breach of contract. So first, we have remoteness of damage. And secondly, we have measure of damages. Now look at what I have done. You know the remoteness of damage, I didn't add S, and then measure of damages, I added S. I don't know if somebody has made a question. Okay, so one Ajua is asking a question. So sir, please, what is the difference between nominal damages and unliquidated damages? Okay, good. Nominal damages, which I have just explained, simply means that because the innocent party, that is the party who is not in default, who has not breached the contract, cannot show any specific loss, any specific injury, which he or she has suffered as a result of the breach of the contract. The court will just award a bit of money. As I said, there is a portrait, that's a token. That's a token. And the reason for doing that is just to give meaning to the common law principle that whenever there's a breach of contract, you must compensate the defaulting party by awarding damages. But the damage is supposed to reflect the loss suffered. But here is the case, no loss has been suffered. But we can show that there has been a breach. So if there's been a breach, let the defaulting party pay something small. And that something small he's paying is what we call like the nominal damages. So let's keep that in mind. And then the Ajua asked about liquidated damages as opposed to unliquidated, nominal damages as opposed to unliquidated damages. Well, the proper distinction is often, let me put it, we often talk about liquidated, right? Liquidated damages, unliquidated damages. Of course, and then you also add another one. This is penalty clause 2. Okay, I'll just say a few words about each of them quickly, and then we move. Okay, so let's start with liquidated damages. Now we understand damages as a monetary compensation for the contract. When we say liquidated damages, it simply means that the parties to the contract, at the time that they made the contract, specified how much money should be paid by one of them to the other in the event of a breach. That if you are in default, how much money should you pay to the other party not in default by way of compensation? So where the parties have made their pre-estimate of the loss likely to be occasion to innocent party in the event of a breach of contract, they will put money value to it, and the money value that they have put to it is called liquidated damages, right? So if it's in a written contract, we call the liquidated damages clause. Yeah, so liquidated damages means that parties have actually pre-estimated, in other words, they have anticipated how much loss is likely to be occasioned to innocent party in the event of a breach of the contract. And for that matter, how much compensation should be paid. So where they have put figures to that is liquidated damage. But With respect to unliquidated damages, the parties have made the contract. When they made the contract, they never discuss how much loss may actually be suffered in the event of breach. And for that matter, they didn't make provision of how much should be paid by the defaulting party to the innocent party. And the court will have to actually make the computation or the assessment. When a breach has occurred, the court will have to help the parties to determine how much loss has actually been suffered by the innocent party as a result of the breach. Yeah, so let us keep that in mind. Of course, you all know very well the Dunlop case, right? The Dunlop where Lord Dunedin, Lord Dunedin gave a very useful explanation regarding liquidated damages as opposed to what they call the penalty clause. See, the problem about liquidated damage is that sometimes what is supposed to be liquidated damage may end up not being treated as such and rather be treated as a penalty clause. And the general position of the common law is that a penalty clause is not enforceable, is not valid, is not binding. The reason being that it defeats the purpose of awarding damages in contract. The purpose of awarding damages for breach of contract is to compensate, not to punish. But penalty clause by its nature is punitive. What is a penalty clause? Penalty clause is where a specified amount of money has been prescribed in the contract as the amount of money to be paid by a defaulting party for breach. And oftentimes, the same amount of money might have been stipulated as the money to be paid in the event of a breach of different types of terms. So different type of terms, and the terms or the responsibilities required to perform may not be the same. And because they are not the same, where there is a default, the consequences are different. And yet, you will notice that almost the same amount of money have been stipulated as compensation in quote to be paid when there is a breach. And the court will say that such a practice will not be recognized as liquidated damage. It will be treated as a penalty clause. And if it is a penalty clause, it is not enforceable. But if it is liquidated damages, it is enforceable. And as I said, the reason for saying that penalty clause is not enforceable is simply that it is against the purpose of awarding damages in contract. Because purpose is not to punish, but penalty clause is really punitive. And you know very well, Lord Dunedin's test from your law school. I mentioned the Dunlop against the New Motor Garage case, in which he said that if the amount stated is exorbitant or excessive, if a uniform amount of money is supposed to be paid for different type of breach, then it will raise suspicion that the amount stated was not a genuine pre-estimate of a loss, which will be suffered in the event of a breach, but it was meant to just hold the other party in terrorem, that is, to intimidate the other party to perform the contract at all costs. But that is not you cannot ask somebody to perform his contractual obligation. In any case, if the person does not perform, you suffer a loss. is supposed to compensate you by way of damages. So let us keep that in mind. So coming back to what we were discussing, whether the parties have actually not made a genuine pre-estimate of how much money should be paid as compensation, as damages, in which case we call that liquidated damages. Why they have not made provision for liquidated damages, when a breach has occurred, what it means is that we have unliquidated damages on hand. The courts will have to help the parties to work out how much damage is recoverable, how much monetary compensation should be paid for the damage or the loss suffered as a result of the contract. So, with respect to unliquidated damages, we have two things. We have remoteness of damage on one hand, and then we have measure of damages on the other hand. So let's say a few words quickly about remoteness of damage. So by remoteness of damage, we are just interested in the nexus, the link, the causation between the breach of contract, which has occurred, and the what do you call it, the loss which the party who is not in default is complaining to have suffered. Now, when a breach of contract has occurred, it is not all the losses, not all the consequences that are compensable that should be recoverable. And the guiding principle, as we know very well, in the old case of Hadley and Basendale, and I'm sure at this stage everybody knows that case, so I need not belabor the point. So damages which are not too remote are damages which are compensable, which are recoverable. And how do we know if damages are not too remote? They are not too remote if they are such as may fairly and reasonably be considered as arising naturally. That is according to the usual course of things. And this is known as the so-called first limb of the in the Hadley and Basendale case, stated by Baron Addison. Or damages are considered as not being too remote if they are such as may reasonably be supposed to have been in the contemplation of both parties at the time they made the contract as a probable result of the breach of it. Yeah, so two ways in which we try to determine if damages are not too remote. And that is why we will open here that, well, when a breach of contract has occurred, you can get general damages or you can get the special damages. And those of you who read Mrs. Zona Hamon's book, The Law of Contract in Ghana, I think she makes such distinction. And of course, it's also consistent with the leading text writers like the Sheshe and Vifort, Nancy on contract, and then Triton. So that is fine. So we could say that maybe the first aspect are general damages, and then the second aspect are what you call the special damages. So for general damages, if you they are just the natural consequences of the breach. So if you take the question that we're discussing, that as a result of the 1 month delay in fixing the air conditioning hatchery, certain number of chicks were destroyed. So where you have a hatchery and then you have been engaged to do something and you don't do it, and if you don't do it, it's going to affect the air conditioning system. Certainly, you should know that if there are birds there, and those birds can only thrive under certain conditions, then where the conditions are not there because of your failure to fix the air conditioning or to fix that particular facility in the hatchery. No, you don't need to be to have the Einstein kind of brain before you appreciate that your failure to fix it will definitely result in those birds who that need to survive a certain temperature. So that is a natural consequence. And so they are considered as fairly and reasonably arising naturally, according to the usual course of things. Or let's use another example. You're a commercial vehicle driver. You take your car to the garage. They tell you that you get the car back in 24 hours. 24 hours time you go and you don't get it. Now, and you don't get it until 3 days later. The damage or the losses that can be considered as arising in the usual course of things from the breach by the garage. That is their delay, their failure to be able to get the car back to you within the stated hours. Will be the revenue which you make on daily basis when you run your car. So once they are not able to let you have it within the agreed period, it should be considered natural that the usual things you use the car to do, you're not able to use the car for. And those should be considered as a loss. That should be compensable, or that you should be able to recover damages for. But there may be other losses which are not considered as arising naturally. And for that matter, they are considered as abnormal loss, or they are considered as special damages. And their recoverability will depend upon the plaintiff making special facts known to the defendant. So maybe if we go back to our question that we look at about the 1,000 checks which the plaintiff expected to have been able to supply to an overseas client. Now, the defendant who was asked to fix the problem in the hatchery could not know that if there was a delay, the plaintiff would not be able to deliver on that contract. On the other hand, if at the time of making the contract, the plaintiff had, for example, made defendant aware that there's no room for delay because he is expecting to deliver 1,000 check to this overseas client, you get the $20,000 and so on and so forth. Now, where such facts or such information had been made available to the defendant at the time of making the contract, then in the event of delay by the defendant, the defendant will be in a position to reasonably foresee or to have contemplated that the plaintiff will not be able to deliver the 1,000 checks to the overseas client. And so that type of loss will be considered as a special damage, or if you like, abnormal loss. So let's keep that in mind. And we know very well what happened in Hadley and Bassendale. Hadley and Bassendale, as you remember from your LLB days, there was a male. The male had the shaft, crankshaft broken. And in order to get a replacement, the broken shaft needed to be carried to the engineers who were based in the Greenwich, and the broken one had to be carried by a carrier to where the engineers were. And the engineers could not make the replacement until they got the broken one. There was a delay on the part of the carrier, and for that matter, I didn't get to the engineers in good time. And it also affected engineer's ability to actually finish the replacement and for it to be taken back to the mill. So clearly, there was a breach by the carrier, and the mill operators sued the carrier and wanted to get damages for their daily revenue and all that, as well as some other special contract that they had. But you, as you remember from Hadley and Basendel, said that, well, you can cover damages which are considered as arising fairly and naturally from the breach of the contract. But as you know, although Hadley and Basendel propounded a very important principle, eventually when the matter went on appeal, the court ordered a retrial because in those days, there was a jury trial in civil cases in the UK. But there was a question as to how the jury were directed. So the retrials. So it's not so much about the ultimate conclusion on the facts, but the principle which was enunciated by Baron Anderson, which has also subsequently been followed on line of cases. And a case that we have to remember when you read Hedley and Basendel is the Victoria Landry against the Newman, because as we know, Lord Justice Asquith provided some crucial clarification regarding how to determine recoverability of special damages or the abnormal loss. Yes, I can see Phyllis would like to ask a question. Okay, Phyllis. Yes, Phyllis, let's hear you. Phyllis, you can mute yourself now. Phyllis, you can mute yourself.
Yeah. Doug, I want us to digress a bit. Right. You were explaining that the two major aspects of damages. You said remoteness of damage to measure of damages. Yeah. And we're making a point that, have we noticed that remoteness of damage S is not added, but the other one, S, is added. You were on the point of explaining, but I think you were a little bit distracted. I don't know whether you would like to make any point on that.
Okay. Well, there is a slight technical distinction, but not too many people actually apply their mind or to that distinction. But if you read like the standard old works, Blackstone's and the Hospice Laws of England and the Treaty on Contracts, you will notice that when we are talking about damage, we are talking about the loss or the injury which have been suffered for breach of contract, or the damage or the injury or loss which you have suffered as a result of particular tort. But you're not talking about tort, but just to also let you know that it also applies in tort law as well. Now, the monetary compensation for that loss, for that damage, is what we call the damages. So it's what we call like the damages. So the monetary compensation for the damage is what we call the damages. So first of all, you always have to determine the damage. In other words, what is the loss? What loss have you suffered as a result of the breach of contract? Or if you're talking about maybe like the tort, what injury have you suffered in relation to that particular tort? But we are not talking about, we are talking about contract. Now, once the loss has been established, then the related task is how do you translate that loss into terms? So translating the loss, translating the damage into money is what we call the damages, because the damages for the monetary compensation. Good. So if you look at of course, we are running very fast, so we can't really go through fully as we do in a normal class, but I think that as questions comes like this, we keep explaining some of the nuances. Yeah, so if you have established the damage which has been suffered as a result of the breach, using the principles enunciated in the Hadley and Basinde and clarify in subsequent cases, especially Victoria Landry and so on. Then the next thing is, how do we put money value to this loss or this damage? So that is where you take our Sale of Goods Act, for example, at 137. It provides some guidelines that, let's say that if you are dealing with the contract for sale of goods, that is for movable goods, and there's a breach, you have to look at the market value and then the contract, the market price and then the contract price. And the difference will be what we pay to you. And of course, it will depend upon inflation and also whether the market price is better than the contract price or the contract price is better than the market price. But let's come back to, yeah, but I don't know, Phyllis, if that's assisted, but let me look at the chat. Have, okay, I think God Love, do you still want me to explain the difference between liquidated and non-liquidated damages? Okay, your question came at the 758. I've done the explanation, but I don't know whether your question came after that or before. Godlove, can you indicate in the chat whether your question has been answered? Can you confirm? Okay, it's not here. All right. All right. Okay. So it's confirmed that it's answered. All right. Okay, so let's move on quickly. Victoria Landry against Newman Industry. Well, in the LLB days, one typical examination question, especially as an essay question, is that sometimes you may be invited to state your opinion as whether the statement by Lord Justice Asquith actually suggests that principles stated in Hadley and Basindel, but Lord Justice Asquith spoke in Victoria Landry against human industry. But Lord Justice Asquith attempted to provide some interpretation or some clarification of the principle in Hadley and Basindel. And students are often invited to discuss whether the principle in Hadley and Basindel is really separate principles or is one in the same principle. So you have to actually bring to bear your understanding the decision in Victoria Landry and especially the explanation by Lord Justice Asquith. Now, as you remember, in Victoria Landry, the plaintiffs had the Landry and they were dyers as well, wanted to extend their business, and they had certain lucrative dyeing contracts. So they entered into contract with the defendant for them to deliver new and a larger boiler, and they emphasized that time of delivery was crucial, was of the essence, so they don't have to delay. Now, the boiler was delivered 5 months later than the agreed contractual time, and plaintiff lost both ordinary profit, that is the profit from everyday operations if there had not been any delay, and also lucrative dyeing contracts in which they hope to have actually made a good profit from. So plaintiffs still seeking to recover loss of the ordinary profit. That is a profit from the normal operations, assuming the boiler had not been delayed, it had been delivered on time. Of course, as a laundry and dyers, they'll do their normal operations and they'll make some revenue. So they were saying that, well, because you have delayed, we are not in business, so we are going to lose that. And not only that, they're also saying that quite apart from our usual revenue that we have made, we're also expecting certain lucrative dying contracts, which could have made us a lot of money. We've not done that. So you need to pay compensation for that. And as you remember, Lord Justice Asquith indicated that, well, when there's a breach of contract, yes, he went back to what Baron Anderson had actually told us, but he sought to reformulate, that is, to restate the principle. And he made the point that when there's a breach of contracts, there is essentially one principle governing award of damages, which states the test as one of reasonable foreseeability. In other words, remember your law of thought, foreseeability in law of thought. And in law of thought, foreseeability simply means that injuries or losses that could have been foreseen, that could have been anticipated, putting yourself in the circumstances that the parties were, the tortfeasor and then the victim. So Lord Justice Asquith was trying to say that, okay, when there has been a breach of contract, the approach is no different from what we know from tort. So in tort, we talk about the reasonable foreseeability, losses that could have reasonably been anticipated, contemplated as going to occur. Should there be, let's say in tort, should there be that particular tort, or in this particular case, in contract, should there be a breach of what contract? That is what Lord Justice Asquith was suggesting. And for that matter, he said that as whether something is reasonably foreseeable or not, as whether we can see that something could have been foreseen, could have been contemplated or anticipated in advance or not, it depends upon the type of knowledge which the parties had at the time of making the contract, and the type of knowledge the parties had concerning the loss you are talking about at the time of making the contract are of two kinds, actual knowledge and imputed knowledge. So by imputed knowledge, Lord Justice Asquith was making the point that every reasonable person is taking to know ordinary course of things. Like every rational person is taking to know ordinary consequences of things. And for that matter, you don't need to have been given special knowledge. Just like the case that we're doing. Let me quickly just jump there. The scenario that the preview, which we look at before we started the class. Like the story between Pink Sheet Poultry Farm Limited and Easy Cook Refrigeration. We know the plaintiffs, they have a hatchery, and in order to kill their broilers, they need to have a certain temperature all the time. So if you have been asked to come and do a backup system and repairs, which will enable the hatchery to be able to keep the chicks at the desired temperature in order for them to survive. Now, where you are not able to deliver the repairs within the stipulated contractual term, you should know naturally that if there are broilers there, they are definitely going to perish because it cannot be kept at the desired temperature. So that the broilers will perish due to your delay, the hatchery not being able to get the right temperature, is the kind of thing Lord Justice asking for talking about in Victoria Laundry, that every reasonable person is taking to know the ordinary course of things. So, the broilers going to perish because the right temperature cannot be provided, and the right temperature cannot be provided because you delayed in 1 month before you're able to finish the repair, contrary to the agreed contractual time. You should know that these are natural consequences, and you don't need to have been told at the time of making the contract. So the knowledge of these consequences or outcome will be imputed to you, will be attributed to you. So that is what Lord Justice is saying with respect to how the reasonable foreseeability is worked out in the Victoria Laundry, applying the Hadley and Basendel case. Then the other aspect is the actual knowledge. So by actual knowledge, Lord Justice asking for saying that for certain losses, before they can be said to be reasonably foreseeable, it will depend very much upon the specific information which the parties have shared. So let's go back to the question that we're discussing. That the plaintiff was saying that it was expected to have delivered the 1,000 checks to overseas client for $20,000. I mean, that is fine. Now, a defendant that you have asked to fix your air conditioning system to enable you to be able to keep the temperature for the best and all that, if you don't tell the defendant that you have this special contract to deliver, there's no way that such a defendant can know, because it is not one of those things which can be considered as natural consequences of having your hatchery in place and so on. But where you have shared specific information with the defendant, then in the event of the defendant not being able to keep to the time for delivery, we can say that when the contract was made, based upon information that we shared with him or her, he or she could reasonably have foreseen that in the event of a breach, you were going to make those losses as well. Yeah, so once you understand these two aspects, it is very easy for you to work out any particular question in relation to this. Of course, there has been like a debate since Lord Justice Asquith, Lord Justice Asquith reinterpretation or reformulation of the Hadley and Basendel, and some subsequent authorities trying to say that it is not right for you to say that the same test should apply in torts and then in contract. But I don't want to really confuse you with those debates. They are not really important, because if we look at even our own cases, the cases of Dustin Smith against KLM Dutch Airlines, you look at the case of Asian against Accra Brewery Limited, and the Dallas Derma case, and all the local cases on damages, as well as the Frafra against Boache, you notice that by and large, the Hadley and Basendel principle, and also as interpreted by Lord Justice Asquith, is what is actually applied in our local jurisprudence. So I think that that is what we need to keep in mind. Now, finally, we talk about measure of damages. And by measure of damages, as I said, how do we translate the loss which you have suffered into money. So the plaintiff usually will attempt to recover the expectation interest. And when we say expectation interest, we are talking about all the expected benefits. In other words, what the innocent party expected to achieve if the contract had been performed as made. So what you expected to gain under the contract, the expected benefits are what you'll be allowed to recover compensation for and what do you call it, the expectation interest. And that's like usual, the normal measure and things like that. And that is why if you bring it, let's say to, if you look at actual computation, okay, let's say that you enter in the contract with somebody to sell a laptop to you, and you're supposed to deliver it in 2 months, let's say in 2 months time, and the agreed price that it is 1,000 Ghana cedis. Now he doesn't deliver it. So there's a clear breach of contract. You sue the person. Yes, there's no doubt that you have suffered a loss. What loss? The fact that you didn't get the laptop and whatever enjoyment you're going to get from having the laptop and all that. We need to translate this into money. We need to find out how much were you supposed to have paid under the contract and how much is the laptop being sold now. Now, the expectation interest in this particular illustration is that if the seller of the laptop had actually delivered it, you are going to get the laptop at the price which you had negotiated and agreed upon. Here is the case the seller has not been able to deliver. So what you have lost is that you're not able to get a laptop at the right time at that price. So the courts will find out how much is laptop selling, or how much does it cost on the market now. You will not be made to buy the laptop at a price higher than what you have paid if the seller had delivered on the contract. Because what you expected to gain was to get the laptop at that price. So where there has been a default in paying, you need to be giving money to put you in the same situation. And that is the expectation interest. Of course, it's not all the time that it is very easy to apply this expectation interest approach. And in recent times, the courts have been open to the idea that there are certain types of contracts when they are breached or broken, the loss which is suffered may not be adequately compensable on basis of expectation interest, as it were. And the court may even award compensation, what they call the loss of amenity. And what, like a very good case to illustrate this is the case of the Rosy Electronics against Fawcett, where the plaintiff contracted the defendants to construct swimming pool of certain specification, that it should be 7 feet and 6 inches maximum depth for diving purposes. The defendant actually constructed the swimming pool and did all that they were required to. The only difference was that instead of meeting the specification of 7 feet and 6 inches, they actually made a swimming pool 6 feet and 9 inches. So there's a certain deficit between the swimming pool actually constructed and what the contract said should be made. Nevertheless, all technical people who inspected the swimming pool agreed that In terms of diving, in terms of comfortable swimming, there was no difference between a swimming pool of the original strict contractual specification of 7 feet and 6 inches and what had actually been delivered or actually made by the defendant, that is the 6 feet 9 inches. So the plaintiff sued, claiming £21,000 as a cost of cure. In other words, as amount of money needed to destroy or rip out the swimming pool made of lower than the contractual specification in order to erect or install the original contractual specification. Now, the court, the House of Laws came to conclusion that that damages will not be allowed. That is the amount of money needed to destroy the swimming pool made in order to make exactly what was agreed upon was not going to be awarded. But the court was of the view that so long as the defendant did not make what the plaintiff had contracted for, the plaintiff had lost something. The plaintiff has lost a certain intrinsic satisfaction, amenity, enjoyment, a certain sense of fulfillment. So to compensate for that, the court ordered that some amount of money, £2,500 should be paid. Yeah, so I mean, we mentioned Resident Electronics just to let you know that it's not all the time that the court may be able to follow the expectation interest in order to do the measure of damages. Then we also have what they call the reliance interest. Reliance interest, where the court cannot actually calculate the benefits which the innocent party expected to have obtained had the defaulting party performed the contract. Then the court will say that, okay, since we cannot work that out, let us find out, has the innocent party, the plaintiff, incurred any expenditure as a result of reliance upon the contract? If certain expenditure has been incurred upon relying on the contract, which the defaulting party has now breached it, the court will say that the measure of damages should be the amount of money which has actually been spent in an attempt to perform the contract. And the typical illustration is the Angler Television Limited against rate, which you know very well. So I'll not belabor the point. So because of time, I will actually just go straight to look at the few multiple choice questions for 10 minutes, and then we end the session and you can go and rest as you go back to work tomorrow. So let's take this questions. Let's look at some of them. Let's say that A hires B to supply. Of course, before I move on, if you have any question which is bothering your mind concerning what I'm discussing, I think we could. Okay, all right. There's no question as such. Okay, so A hires B to supply disco for his event. A pays B, let's say 5,000 for 5 hours work upfront. After 1 hour in breach of contract, B leaves and takes his equipment with him. One of the audience volunteers to DJ the rest of the event for free and is a total success. A therefore suffers no loss. How much might A be able to claim back from B? When we finish this particular question, I will take the question by Francis John Aniaba. So Francis, just hang on for a second. Yes, so we have A. £0. B, nominal damages. C, 4,000. D, 5,000. What do you think the answer is for 18? You can indicate it in the chat. We have 4 options. What do you think is the answer? Okay, let's go to the responses. Okay, we have responses. Okay, let's take a few and then we pass the judgment. Okay, so we have some people are saying B, nominal damages. Okay, let's see if there's any other. Okay, that is if. Wow, okay, you've gotten another different answer. 4,000. Okay, this is what I'm going to do. I'm going to release one of those who opted for B and release one of those who opted for C. And I will allow you to explain why you think that it is B or it is C. And then I will give you my verdict, right? So let's say those who opted for D, if one of you can put up your hand, those who opted for B, can one of you put up your hands so that I'll release you to explain? Okay. All right. So B, God love.
Doc, so nominal damages are awarded to a party which has suffered a loss, but without any actual amount of loss being indicated. And at the end of the question, they said, though he has suffered some loss, they didn't specify the loss that he was paying.
No, I think they said that A therefore suffers no loss. You look at the question, A therefore suffers no loss. How much might A be able to claim back from B? God love.
Yeah. So Doc, if you look at the meaning of nominal damages, it is awarded to someone who has suffered a legal wrong, but not actual financial loss.
Okay, all right. Now let's take one of those who opted for C. If you can put up your hand, then I will release you. I don't know whether Francis, John, and but you opted for C. Otherwise, okay. Francis, C, why did you C?
I didn't. I raised my hand to ask a question, and you asked me to hang on.
Oh, okay. Okay. Yeah. So if you, look at this. This is pretty straightforward. Although it is tempting, if you see A, 0, and then you see B, nominal, but certainly there's nothing like 0 cedis or 0 pounds, isn't it? So that is not the point. And if you did that, that would be wrong in the sense that we have, by nominal damages, we are told where no has actually been suffered, we still awarded some damages, no matter how partial or token that it might be. And certainly, if it's going to be like a token, it will definitely be more than 0. So A is completely out. So last year, I used to teach some of those who exams an approach of solving multiple choice questions, which we call the elimination method. So the elimination method simply means that where you are not sure of the correct answer, you can be canceling out some of the most obviously incorrect answer, and then you may be left with the correct answer. If you are not sure of the correct answer, and you often be correct in getting the correct answer, despite the fact that you actually did it know it. Or sometimes you know it, but you can use the elimination method to assure yourself that it's absolutely. Yeah, so that is another way. So let's say you take A, certainly there's nothing like £0, so that is out. You come to nominal. Let's suppose that you are not sure whether B is the correct answer. Let's go to C. 4,000. 4,000. Has any 4,000 been lost in the story? How do you arrive at 4,000? Because no 4,000 even stated, isn't it? So certainly that one cannot work. Let's come to D. £5,000. Okay, 5,000. How does it come in? Let's look at it. A hires B to supply a disco for his event. A pays B 5,000 for 5 hours work. After 1 hour in breach of contract, B leaves and take his equipment with him. Okay, so can we go for 5,000? We are told that A pays B £5,000 for 5 hours work upfront, meaning that upfront means that the payment has been made, isn't it? The payment has been made. But B, that's just 1 hour.
So he did not lose, but there's a breach.
Abandons the work. And we are told that one of the audience have volunteered to do the rest of the event for free, and everything is successful, but A therefore suffers no loss. So how much might A be able to claim back from B? So 4,000 and 5,000. Now we need to do a little bit of math here. 5 hours is 5,000, isn't it? So the person did 1 hour. Now, if 5,000 is 5 hours equal to 5,000, how much 1 hour be? 1 hour be how much? God love, you are the one I've released, so you have to supply the mass.
Dog, if it's
equal to
yes,
5 hours equal to 5,000. Okay, some people have done some, yeah. Okay, so 1,000. Okay, so 1,000. But if you pay attention, that is why we have to be careful. Otherwise, we can easily get a simple question wrong. We are told that A has paid B, has paid him upfront. So upfront, what is the meaning of upfront? And the upfront means immediately. Is that not so?
Yes.
If you look at the dictionary, upfront means like it's paid at
the word go.
Yeah, from the word go. So the understanding is that the 5,000 has been paid, but only good. So somebody has said in advance, okay, that is fine. So £5,000 has been paid for 5 hours work, but you did only 1 hour, and then you abandoned the work. So applying quantum merit, 1 hour you're entitled to 1,000, meaning that you have 4,000, which will amount to unjust enrichment if you are made to hold on. So you have to refund how much? You have to refund 4,000. Because the question is, how much might A be able to claim back from B? So those who opted for C, they are correct. Those who opted for B, they are wrong. Those who opted for A, they are wrong. For D, they are wrong. So we see how it's tricky. You see how it's tricky? Because the question is that A therefore suffers no loss. So how much might A be able to claim back from B? Because we cannot ignore, we cannot ignore the word upfront. we cannot ignore the word upfront. Okay, so, okay. Now let's look at another one or two before we go. Which of the following statements about penalty clause? No, I'm not being fair to Francis. Francis, please, let me take your question before we move on. Francis, you can unmute yourself. Francis John and Yaba, yes, please.
Yes, it was more of a clarification from you, sir. Right. You said that court would not uphold penalty clauses in contracts. My question is, or where I'm getting, so the court under no circumstances would also, in applying any damages as that required, apply punitive damages on any of the any party, and is it only in relation to contract, or it applies also in torts?
Okay, good. In law of contracts, fundamentally, and that is why I like the old case of Robinson and Harman, right? I like the old case of Robinson and Harman, in which the point has been made that the aim of awarding damages is to put the innocent party in the position that he or she will have been in had the contract not been breached. So certainly it's not meant to punish. Awarding damages in contract is never meant to be punitive. So that should be the starting thing. It's never meant to be punitive. Of course, there is this school of thought in the literature that what about penal interest when it comes, let's say, that the loan contract and things like that. Now, where you have a clause which is supposed to be punitive interest, maybe the language might have been used as such, but in reality, for purposes of contracts, that is not the proper concept. It may still probably, depending upon, it's not, and it's not so much about you calling the penalty clause, which is decisive, just like what you're doing in terms of contract. It's not when you call something a condition or warranty, then the court will treat it as a condition or warranty. But more importantly, the court will look at the content of the obligation and the intention of the parties. The intention of the parties make it a particular obligation a condition, despite the fact that they might have described it as a warranty. The court will ignore the label and look at the substance. So in the same vein, it's not you just using the word penalty clause, then automatically it is a penalty clause. No. And that is why Lord Dunedin's test in the Dunlop pneumatic tire against the new motor and garage is very important, that the court will find out whether the amount is excessive, is exorbitant, having regard to the maximum loss that can be suffered in the event of a breach. You see? So all those things are important. In law of tort, punitive damages are permissible, especially when we are even dealing with the defamation, things like that. They are permissible. But in contracts, damages are not punitive. Francis, I don't know if that assists you. Okay.
Yes, sir. It does. It does. It so much does. Thank you very much.
Okay. Somebody has provided the answer to question 20. That is D. Which of the following statement penalty clause is false? No, but see, before I go on to question 20, it's interesting. I think one gentleman, let me see. The friends is saying that no. I think the previous question, there was only one person who opted for C. I think one or two. But when I asked that one of you should raise up your hand so that you explain why you opted for C, Nobody raised up his or her hand. Meanwhile, you had the correct answer, and the majority who had opted for B, they were wrong. Anyway, let's come back to 20. Which of the following statement about penalty clauses is false? A clause may be a penalty clause for the transfer of property rather than money. B, a clause may be a penalty clause even if it is labeled by the parties as liquidated damages. C, a clause will always be a penalty clause if it does not represent a genuine pre-estimate of loss. D, none of the options given is correct. Okay, now I think this may probably be the last question for tonight, because you can see I'm still sitting in my office and I have to drive up before I get home. So if we look at the options given for question 20, let's apply the elimination method. An elimination method, as I said, simply is a strategy of desperately trying to work out the correct answer, even where you are not very sure. So let's start with A. A clause may be a penalty clause if it stipulates for the transfer of property rather than money. Certainly. I mean, this will come to you and say that even if I don't know penalty clause, I don't think this is the something I will present it. So you try and let's say you strike that out. Let's take a B and C. A clause may be a penalty clause, even if it is labeled by the parties as liquidated damages. Oh, sorry. The question said, which of the following statements of a penalty clause is false? Okay. All right. So we have A. So A true about penalty clause, and then that should be like the question. And you see how we can all fall into the pitfall or the trap of not paying attention to wording of questions. And that is why some of us will go into the exams thinking that, oh, this exam I should pass because the things I learned, they all came. Now, if we don't pay attention to the wording of, let's say, the MCQ, you could end up getting a good number of them wrong, you see? So please, let's be careful. So which of the following statements about penalty clause is false? That is not true. Is it true that a penalty clause, a clause is penalty if it's stipulated for transfer of property rather than money? Is that what makes the penalty clause? Certainly not. Let's look at B. A clause may be a penalty clause even if it is labeled by the parties as liquidated damages. Is that true? Is that true? That is true, because that is the ratio in the, I mean, with Lord Dunedin propounded Dunlop case. And that is why it will say that to look at, it will be tested. Is amount stated excessive and so on. So that if you've even headed it as liquidated damages, that will not be, if you like, conclusive of the matter. So let's keep that in mind. So B is true, so it cannot be the answer. C, a clause will always be a penalty clause if it does not represent a genuine pre-estimate of loss. And then that is also true, because we have seen that. Then D, none of the options given is correct. So now we have to battle it out between A and D for the correct answer. So let me look at your answers from the chat, which you have given. Okay, some have gone A. Somebody said a B and C and D are true. Okay. So let's take A. Let's look at the A. A clause may be a penalty clause if it stipulates for the transfer of property rather than money. Is that really true? Certainly not. Certainly not. So that is false, isn't it? Now, although D, none of the options given is correct. D is wrong because one of the options given is correct in terms of its falsity about penalty clause. A is false as far as penalty clause is what is concerned. And for that matter, the correct answer is what? Is A. This is where we'll be ending the class. Let me see if there's a 1 or 2 questions, then I'll take a 1 or 2 questions, and then we end for the night. John, you have a question again? Okay, let's see. John? Yeah, oh, Do hands has only been there for a long time. Okay, John, then Do.
Okay.
And then,
Okay, so my question is on the solutions we just gave. I know this is an extension, but couldn't we also argue that instances where it like this for the C, it says that when it is not a genuine pre-estimation of actual costs incurred. Is it also possible that, okay, we, instead of the actual cost incurred is 10,000, but the person estimates 8,000? Does it make it punitive? And wouldn't that qualify as a different pre-estimation of the actual costs? And that indeed, this statement could be extended to before.
Good. I think the emphasis is on the word genuine. And if you look at Lord Dunedin's statement in the case, I think that word is also used, genuine pre-estimate. And that is to say that what has been stated is not excessive, having regard to the maximum loss that can be suffered. And so I think that is how we should approach it. But let's forget about the specific of this particular question. But at least that is the most important understanding that we should have in mind.
Yeah, I agree with A, but I just wanted to say the argument can be extended to that.
All right, Francis. Okay, let's take Ales. Ales has idea for a long time. Ales, and then after Ales, we take Joshua, and I think that should be it for the night. Yes, Ales.
Yeah, hello, Doc.
Yes, please.
Yes, please. I would like to take us back to the first question. The £5,000 is really getting me a bit confused, because when I study that question, there's an element which says that there was no loss in the calculation. You know, because there was 5,000 payment to Mr. B, so thereby, you know, I really don't get it, because in any case, there was a free supply of DJ. There was a free supply which covers up.
Yes, Ales, I'll not let to waste your breath. I think that there's what you call the red herring, right? Pitfalls are thrown into questions. So you are told that A has suffered no loss. But a statement has also been made that a certain amount of money was paid for a certain number of hours, 5,000 paid for 5 hours, and only 1 hour was done. So we try to find out if 5,000 for 5 hours, then 1 hour will be how much? If the meaning of upfront is to say that A had actually paid the 5,000 to in advance or ahead, then if B did just 1 hour, and we ask the question, how much might A claim back from B? Certainly, it will be the 1,000 cedis. Despite the fact that we are told that A suffered no loss, of course, and that is a temptation for us to gravitate towards nominal damages. So let's keep that in mind. Okay, so let's take the last one, and then I didn't hear any female. We have our female here. Okay, so if they are not asking, it means they are clear. Good.
Yeah, Doc.
Yeah.
Thank you. My question has to do with damages that you have explained earlier. A has signed a contract with B, and to procure works, putting up a building, and B has not met the specification according to Section 3 of the Sale of Goods Act, fit for purpose, and A refuses to pay B, is there any damage? Because A is arguing differently that he has not issued purchase order for B to proceed on the project.
All right.
Is there any damage?
Joshua, let's
Yeah.
straighten ourselves or correct ourselves. If you mention the Sale of Goods Act, right, and all of us, let's pay attention. The Sale of Goods Act is applicable to contracts for movable goods, for sale of movable goods. It's not for, I feel like necessarily contract of service. Contract for sale of movable goods.
Okay, then let's talk about laptop.
Okay, yes, so can you come again?
Each of the building have replaced with laptop.
Yeah, so tell us. Yeah.
A has signed a contract with B to procure laptop,
Okay.
but has not issued purchase order to B, and A is arguing the specification of what he has requested for, and he has not issued a purchase order for B to procure the thing before B proceeding.
Joshua,
Yeah.
if you have such a type of question, I will usually prefer that you put it in the chat so that you put your thoughts clearly, and then all of us read it and then we will analyze it together.
Okay. Yeah. I'll do that in the subsequent meetings.
All right.
Thank you
very much. All right. So all of you have a very good night, and then Saturday morning we try and have some early morning if those of you can join us. But this will be on the YouTube, so you can go to the YouTube, either you subscribe or you view it or whatever. Okay. Have a very good night.